Good morning, afternoon, everyone. Thanks for attending today's webinar about information blocking. It is my pleasure to introduce you to Andrew Kessler, who is the founder and principal of Slingshot Solutions. For the past decade, Andrew has been a fixture in circles that advocate for addiction treatment, prevention, recovery, and research. We graciously asked Andrew to share his perspective on this new information blocking rule and provide preliminary guidance to Best Notes customers like you. If you have any questions for Andrew, please enter them in the Zoom Q&A box, be at the bottom of your screen. Also, as a side note, Best Notes will be following up in the next few days with an email with a link to today's webinar and more information about how to use specific Best Notes features to securely share patient health information. Andrew, thanks again. Please take it away.
Absolutely. Well, thank you. And thank you all for attending. Just a note before I begin, on my webinars, I tend to get a little animated. My presentations are a little quirky, and there's a reason for this. One, it's just my personality, and two, I've been on plenty of webinars where by 15 minutes in, someone's just reading their slides, and I know that that will put people to sleep, especially around lunchtime. So I like to keep everyone on their toes and like to make it a little fun. So with that, we'll get started. As I was introduced, I have 26 years in policy and advocacy. I'm based in Washington, D.C., in Fairfax, Virginia. And about 20 years of that, I've been in behavioral health. And the first thing I want to say before my disclosure is, yes, I've been in DC for 26 years. That makes me a very committed to the political process. And as a result, I didn't sleep much last night because I was watching the election results, like many of you may have been. And I always watch the elections, not from a personal standpoint, but from a standpoint of a student. I was like, fascinated by campaigning, and I just like to observe, see what went right for certain parties, see what went wrong. And this was a fascinating election to dissect, let me tell you. So absolutely fascinating. So I've been doing that most of the morning. So if my eyes start to close a little bit, apologies in advance. There is one ethical disclosure. I do have a JD, but I am not an expert in compliance law or IT law or intellectual property. I'm a policy expert. So my goal today is to make you more aware and more familiar with the policy that has been enacted concerning information blocking. A lot of the questions you may have could get into the area of law, of specifics, and that's where I'm going to have to, draw a line, because ethically I can't answer those. Yes, some lawyers have ethics, so anyway. I want to start off with a little quote from a great movie. The movie Wall Street is famous for the quote about greed being good. But my favorite line from the movie is something completely different. The most valuable commodity I know of is information. Wouldn't you agree? Gordon Gekko says this to Charlie Sheen soon after they meet. And it really is true. If you were like me and you were watching, I don't know, let's say the politics and the political races yesterday and the campaigns, what was everyone doing during the day? No one was really reporting the news. Everyone was prognosticating. Let's take the information and crunch it and see what we can learn. I turn on ESPN because I'm a huge sports fan. No one's talking about what happened. Everyone wants to talk about what's going to happen. Well, what do you need to do that? You need information. It's incredibly important. And it may not be much different in health IT. Information is kind of the lifeblood. Why do people go to doctors and healthcare professionals? To get information about their health. So it's an extremely valuable commodity. And you all in attendance, work for businesses that are safeguarding information. So it is the commodity. In 2016, the 21st Century Cures Act was passed. Now, I'm going to tell you a little story about the 21st Century Cures Act and why information blocking was in 21st Century Cures. This started as a bill that was really about drug pricing. Fred Upton of Michigan started this legislation about drug pricing. And as the 2016 legislative calendar started to get smaller and smaller, and the window started to close, and the elections were coming, people weren't sure if it would pass, even though there was a lot of momentum behind it. When Donald Trump won the 2016 election, and the Democrats realized their window to pass such legislation was just about to close, the legislation absolutely took off and blew up. And everybody on Capitol Hill who had any concerns about any aspect of healthcare tried to get it into the 21st Century Cures Act. That's what we call a Christmas tree on Capitol Hill for two reasons. One, what do you do with a Christmas tree? You keep throwing things on it. More tinsel, more popcorn, more ornaments. You just keep throwing things on it. And at the end of the day, there's something under the tree for everybody. So pharmaceutical companies, I know in substance use disorders, we got a $500 million grant for opioid response to the states. And those in health IT, well, you've got the information block. That got into the bill too. So we're going to talk a little bit about how it came to be and what it is. Information blocking is a practice by an actor that is likely, keyword, likely to interfere with the access, exchange, or use of electronic health information as required by law. And it's applied the law to healthcare providers, health IT developers, and health information exchanges, as well as health information networks. It's always best to start with the law itself. I know a lot of people who will say, oh, that's legalese. You know, legalese is just a word for elaborate English. If you can read the English language, you can unpackage this. It's just going to take a while. So we're just going to be really simple and look at the definition. As I said, if it's likely to interfere with, prevent, or materially discourage access, exchange, or use of electronic health information, and if conducted by a health information technology developer and the like, that is likely to interfere, not will, but likely to interfere, or if it's conducted by a healthcare provider, such provider knows that such practice is unreasonable and is likely to interfere. In law, we call this the mens rea. There's two elements to every law. The actus reus in Latin, which is the act, and the mens rea, the mind, the intent. So is it likely to interfere? That's the standard. It doesn't have to interfere in the end. If it was likely to interfere, it could be information blocking. So a little bit more on the law itself. This is the actual language. Practices may include practices that restrict authorized access or exchange under applicable state or federal law, or implementing health information technology in non-standard ways that are likely to substantially increase the complexity or burden of accessing, exchanging electronic health information. And one more thing, implementing health information technology in ways that are likely to restrict access, exchange, or use of electronic health information. And my favorite, and by my favorite mean the one that makes me most exasperated, lead to fraud, waste, or abuse. Fraud, waste, and abuse is one of those taglines we have in Washington. A lot of politicians will tell you, well, we'll just get rid of the fraud, waste, and abuse. Well, one man's fraud, waste, and abuse is another person's, well, maybe not. There's no line in your books as vendors, as companies, that says fraud, waste, and abuse, and you put it in there. It's a really subjective definition. So that's the only thing about the law that's kind of a little fuzzy. The rest of it, I think, is pretty straightforward. You'll notice the language keeps repeating itself. Restrict access, exchange, or use, information, and the access, exchange, or use. In every section, we see that language. I don't think the lead to fraud, waste, or abuse or impede innovations aspect is what anyone needs to worry about. In preparing for this, I think what we're really concerned about here, or what we need to learn about here, is what you as actors need to know about in terms of the exchange of information with patients, practitioners, and other vendors. So now let's break it down. Now we're going to be outside the legislation itself, and we're going to look at certain definitions. And a lot of legislation, all it does, if you read it on the page is it refers to other legislation, the US Code. It says, actors as defined by. So we need to go to that area of the law. So when the law says healthcare provider, what they mean is a provider is any person or an entity that provides services. The term could indicate a physician, a nurse, a nurse practitioner, physician's assistant, pharmacist, and many such individuals. Anyone who is in the business of providing healthcare through their professional service. A health information network or a health information exchange provides doctors, nurses, pharmacists, and other healthcare providers and patients with access to a patient's vital medical information electronically. I use one myself in preparing for this webinar. I actually had a telehealth appointment last week as I was, putting this together, and I was talking to my doctor over my link, and it was all electronic, covered by a HIPAA compliant software, the whole bit. So very common these days, especially post-pandemic. And health IT developers of certified health IT. Health IT developer of certified health IT refers to an individual or entity other than a healthcare provider that develops the IT for their own use. So electronic health information is electronic protected health information to the extent that it would be included in a designated record set. Well, now we need to define that. So now we're getting into, as I said before, legalese. It's not that the words are difficult to understand, it's that it just keeps going further and further down the rabbit hole. So now we've defined who the actors are, we've defined what electronic health information is, and now we've got to define what a designated record set is. And that's something that includes a group of records maintained by, or for the healthcare provider, that is individuals for their health care, or used in whole or part by the healthcare provider to make decisions. Just as important, and this is going to be a moderately important theme through the rest of the next 45 minutes together, is what is not electronic health information. It's just as important to know what is not considered information in the information blocking scope. I remember in law school, what they always made us do in moot court was you would argue your side of the case. And the next day, you know what you had to do? You had to argue the other side. So you have to know what is included, and it's very important to know what is not necessarily included. So those would be psychotherapy notes, information compiled in reasonable anticipation for use in a civil, criminal, or administrative action proceeding. That's protected by privilege. Individually identifiable health information in education records, individually identifiable health information in records for health information in employment. So school, employer, not considered electronic health information. Individually identifiable health information regarding a person who has been deceased more than 50 years. I don't know where 50 came from. I guess it's a nice round number. And you could say it's arbitrary. I know in law school, usually numbers go by generation. So usually numbers are 18 to 25 years. That's what they figure a generation is in certain laws, but they pick 50. And if something has been de-identified, it is not considered an electronic health information. So the Cures Act established two different knowledge standards. Remember what I said before about mens rea, when the legal term mens rea, the mind. What is the mind doing in terms of its intent? So there's two different standards for what an actor has to be thinking for it to be considered information blocking. Now we're into the actual act of information blocking, and there's two different standards. One is whether the actor knows or should know that a practice is likely to interfere with access, exchange, or use of electronic health information. And the other is whether they know that the practice is unreasonable. Okay, so those are the two blocks. There's, I believe, 8 areas that we're going to get into in just a minute. I want to be clear about one more thing before we get into those 8 areas. The electronic health information definition incorporates terms defined in the HIPAA rules that are used by the healthcare industry. So a lot of this is not new. It's kind of a, I don't want to say a codification, but it's looking at it from a different lens. You know, a colleague I work with on this said it's kind of reverse HIPAA. You know, whereas HIPAA means you can't give out certain information without a patient's consent. This is more, you must give the patient this information. So it's just HIPAA through a different lens. It focuses on a set of health information that HIPAA covered entities and business associations collect, maintain, make accessible. And the electronic health information is a subset of the same information. So we're not hitting you with a lot of new knowledge. I can't see your faces, but a lot of you may be saying to yourself, this sounds a lot like HIPAA, because it is. The standards are very, very similar. So this is a pretty simple, I don't want to say simple, but you know, it's a different way of looking at it. It's a visual chart rather than reading words on the screen. And I also wanted to change it up. Like I said, if I were to show you slide after slide of just words on a screen, you know, I want you to stay awake. So if the information is individually identifiable health information that is maintained in electronic media and would be included in one of the following records, billing, enrollment, or records used to make decisions, and is not one of the exclusions, then it is considered an electronic health information and it is covered by the information blocking statute. Okay. The key to any rule, just as important as what's in the rule, is the exceptions. When I was in law school, I had a professor for evidence. He was the classic law school professor that scared the crap out of everybody. People were terrified of him. Very imposing figure. And he actually wrote the bar exam questions for the state of Maryland. That's how difficult his class was. And evidence, the key to evidence is something called hearsay. As I'm sure any of you watch Law and Order, like to watch any courtroom drama. What is hearsay? It's an out-of-court statement. And the professor on the first day said, here's the key to evidence. Hearsay is inadmissible. We will now spend the next 13 weeks studying exceptions to that rule. It's not about the rule, it's about the exceptions. So you need to know what is accepted, so you don't need to worry about whether something is considered information for the purposes of information blocking. So let's get into those. There's 8 exceptions divided into 2 categories. Exceptions that involve not fulfilling requests and exceptions that involve procedures for fulfilling requests. Another reason that my law education helps me as a policy analyst is there's 2 ways to break down every problem. There's the substance and there's the process. In this case, the substance is the information. And the process is what do we disclose and what do we need not disclose. The first group of exceptions, exceptions that involve not fulfilling requests, that has to do more with the substance, the information. Are you going to be giving away? Are you going to be disclosing that information or not? The second part, the procedures. Exceptions that involve what you need to do or need not do. So we're going to get into those real quick. Exceptions that involve not fulfilling requests. The preventing harm exception. And I'm not going to read this to you. You can see it. This is being recorded. We can distribute it. You can take a screenshot. I don't care. It will not be information blocking for an actor to engage in practices that are reasonable and necessary to prevent harm. Pretty simple, because we're in the medical industry. What's the rule? First do no harm. So that's first. The privacy exception. It will not be information blocking if an actor does not fulfill a request to access exchange to protect privacy. Okay. The security exception. It will not be information blocking for an actor to interfere provided certain conditions are met to protect their security. So these are pretty reasonable. So those are there's two more, I believe, under not fulfilling. Infeasibility. This one gets a little more complex. The first three are simple, you know, and kind of self-explanatory. Infeasibility is a little more abstract because one person's infeasible may not be another's. But as you can see, it will not be information blocking for an actor to take reasonable and necessary measures to the degree that the performance for the benefit of the overall performance of the health IT is not endangered. And finally, the health IT performance exception. So those are the 5 exceptions that involve not fulfilling a request. Any of these exceptions are met and information is not disclosed, it is not information blocking. Then there's the 3 exceptions that involve procedures for fulfilling requests. The content and manner exception, which has to do if you're limiting content in response to a request, provided certain conditions are met. The fees exception, it will not be information blocking if fees that result in a reasonable profit margin for accessing or exchanging information, if those conditions are met, and the licensing exception, as you can see there. So that has to do with the procedures for fulfilling request to access, content and manner, fees, licensing. These are the procedural exceptions. All right, so I've mentioned the process, and it's important for you to know how the process works on the other side. Let's say someone is aggrieved and they want to initiate proceedings against the actor who they believe is engaging in information blocking. This is important because up until now, it's all kind of abstract. This makes it a little more concrete. This is when I feel you have wronged me and I want a remedy. And the remedy is civil, not criminal. That's important. You will not, let's say by some mistake, you are accused of information blocking and you are being questioned, investigated, what have you. At the end of the day, the penalties are civil. No one is putting the cuffs on you. It is monetary payouts up to $1 million. The process for that is something we're not going to get into too deep today, but it is a civil penalty. So first and foremost, it's not criminal. No one's going to jail over this, unless it comes out that, you know, somehow there was, I don't know, fraudulent behavior, but we're going to assume that that's not the case. So through this process alone, it's only civil. So if a consumer believes that a HIPAA-covered entity violated theirs or someone else's health information privacy rights or committed another violation or security breach, they file a complaint with the HHS Office for Civil Rights. The Cures Act states information blocking claims are then referred by the Office of the National Coordinator of Health IT in connection with the claim or suggestion of information that blocking are generally protected under FOIA, the Freedom of Information Act. So it is filed with the Office for Civil Rights and is referred to the Office of the National Coordinator. The Office of the National Coordinator for Health IT is really the adjudicator, the main player in enforcement. The Office for Civil Rights is really kind of the doorway, but the Office of the National Coordinator for Health IT is the playground that you'll be playing in. Another chart. I like these charts. They make it kind of simple. This is how it would work for someone filing a grievance. ONC acknowledges receipt. Is the claim against a healthcare provider? You can see if yes, if no. Is a claim against a health information network? That may apply to the audience today. Or is it a claim against an offerer or certified health IT? You know, if it's no to all of those, they don't want to deal with it. You know, you got to fulfill one of those requirements. So, but you'll see at the other side, It's always the OIG, and that's the office. Sorry, I speak in acronyms. That's what we do in DC. We've got over 2,000 federal agencies that work here. So we speak in acronyms. OIG is the Office of the Inspector General, which is the internal auditor for each agency. Every agency has an IG. And the IG's role is to be the internal auditor, to make sure everything is going according to procedure. So they are the office within Health IT that will review these claims. And there you have it. It's also important for you to know who is filing these claims in an attempt to put a more human face on who deals with this. So you'll see the bulk is patients. And the rest kind of breaks down. You know, the second biggest is third party on behalf of patients. So if you were to add those two up, that's a really significant bulk. Then you have the attorneys who are filing, probably also on behalf of the patient. And then you've got about 16% that are filed by either an IT developer or a healthcare provider. And I can only imagine those are possibly against similar vendors in their space when they're trying to share information and didn't get a full disclosure. That's only an assumption on my part. I can't see why healthcare providers or health IT developers would be, why else they would be filing information blocking claims. The unknown kind of puzzles me. There's so much good information on this that, you know, I maybe they just can't classify it. So I'm just going to put this a different way. I think this is a way to really see how much of the bulk of the grievances are filed by patients themselves. It kind of dwarfs all the others. So, you know, there you got it. Then a couple more charts. Claims by potential actors. That is the other side. Who is the claim against? 76.8% is against the provider. Okay. The audience I'm speaking to today, or if I understand this right, is not providers. So the bulk is on the providers. Then you have the rest that are just, you know, fill up the rest of the chart. Or put another way, I mean, it's pretty clear who the grievances are with. I know for one thing, just as a simple, rational person, if I were having a problem with my health records, the first person, and I needed to actually get to the point where I filed a complaint, the first person I would complain is my provider. Dr. X, where are my records? You know, and if they were to tell me, oh, it's not me, it's the health IT, I don't want to hear it. I want to hear from my provider. That's what you're responsible for. So, you can see that providers are getting the bulk of the claims. Let's talk raw numbers, because again, in taking the abstract and making it concrete, I want you to have a look at the raw numbers. So this has been in existence, I guess 5 years now. That's not a lot of claims. It's really not. Total number of information blocking portal submissions received, 511. These numbers are pretty current. You can see they're not more than a month old. Total number of claims, possible claims, 476, and the total number of submissions that did not appear to be claims, 35. You're going to have to assume that if someone's going to go through this process, they understand what I'm pretty up to speed on my own health and keeping track of my own health records with my provider. And I am a person who worked on parts of the 21st Century Cures bill personally and helped to write provisions for it. And up until maybe a year ago, I'd never even heard of information blocking. So people who engage in this are pretty sure to actually have a legitimate complaint. That's why 476 of the 511 have actually gone forward. Only 35, which looks like is 7%, don't go forward. So that's the process for a complaint to be filed under this statute. Okay, now part two of all of this. A lot of people, and I don't blame them because I grew up watching Schoolhouse Rock, how a bill becomes a law, House passes it, Senate passes it, President signs it, It's a law. Done, right? No, you're not done. Because almost every law has to undergo a process called rulemaking. This is where the blanks are filled in. Because what a law will say is, okay, Office of National Coordinator, you're in charge of this. Or, if you have a complaint, it will go through the Office of the National Coordinator. Fines will be determined by that. All of the things that are not defined by the statute are defined in rulemaking. And if they're not defined in the rulemaking, I guarantee you they'll be defined in litigation later on. So the process of rulemaking is quite important. It's where you think of it as when you pass a law, you've produced a coloring book. But a coloring book is nothing unless you color it in. Rulemaking is the coloring it in inside the lines, and you better stay inside the lines. So it takes a very long time for rulemaking. This law passed in December of 2016. The rulemaking process just finished up last month. That's how complex it is. Okay. Now, rulemaking, don't think it's done in the dark. There are, the law is, every time there's rulemaking, there's an opportunity for public comment. If you're a citizen of the United States or a corporation or an association, anybody can make comments on the rule and say, this is how I think it should go. It is just as important a part of the advocacy and lawmaking process as the law itself. If you're someone in my position who works on legislation for a living and you pass a law and ignore the rulemaking, you haven't done your job. So it fell to the Office of the National Coordinator for Health IT to do the rulemaking. And the scope of the 21st Century Cures Act information blocking rule expanded, it was announced, to prohibit healthcare providers from blocking or interfering with a patient access to any electronic health information in a designated record set as the term is defined by HIPAA. Now, okay, what does this mean? Before we get into it, remember that I said that anyone can take part. 28 different health IT professional associations, for all I know, people on this webinar, and other stakeholders asked the Department of Health and Human Services for more clarity on flexibility. They're like, we are not ready for this rule. We know your rule's coming out on October 6th. We are not ready. We need more clarity. We need more definition. So if you're here confused, sometimes it's just nice you're not alone. That's a calming thing. Hey, I'm confused too. Oh, it's not just me. 10 major professional trade organizations wrote on October 2nd, less than a week before the rule came out, that their members are making every feasible effort to prepare for the deadline. The group said it was evident from their conversations that they are not fully prepared. No one's coming after you if you're not fully prepared, okay? There's no Office of National Coordinator, Health IT, police force that's going to knock on your door and say, hey, are you in compliance? Not happening, okay? So don't worry. You just have to make your best effort to be in compliance. And you can see what was written in terms of confusion over this rulemaking process. Okay, the October 6th rule broadened the scope of information blocking that were put into effect in the previous iteration of the rules that required health IT vendors, providers, and health information exchanges to enable patients to access and download their health records. What does this mean? Well, the Deputy National Coordinator for Health IT wrote a blog post on this, okay, offering reminders and trying to explain as simply as possible what this all means, okay? We are no longer limited to the data elements themselves represented in the core data for interoperability version, the last version of the rule. As of October 6th, information blocking regulations apply to all electronic health information in a record that qualifies as protected by HIPAA, okay? Previously, providers only had to make available data elements in a specific data set that was defined that we discussed earlier. The key to this is that line in the middle, and that's why I set it apart. It's not the mechanism. anymore. It's not the electronic health record that you use, it's the data itself. The key here, while the facts and circumstances that an actor may face with respect to the scope of electronic health information has changed, an actor's approach to meeting an information blocking exception generally remains the same as before. It's how you treat the data itself. It's, basically it makes it more difficult to say, well, it was in this kind of record, it was in that kind of record. It's the data itself that they're concerned about, okay? Was the data blocked in any way? Even though technology-related practices come up as a top-of-mind example, information blocking practices are inclusive but not solely limited to them. That's what this rule is saying. Other acts, contract negotiations, terms, other omissions could prevent, materially discourage, or otherwise inhibit the access. So for example, if you are in a transaction with another vendor or you're making a deal, whatever, and you do something that will down the road end up blocking this information, that's what you need to be aware of, okay? It's the data itself that they're concerned about. Many states already legally require reporting of certain diseases and conditions to detect things like outbreaks, reduce the spread of disease. We're hyper alert to this right now. Should an actor that is required to comply with such a law fail to report, for example, the failure could be considered information blocking under the use. That's another, codification or clarification in this rule, okay? The good news, if there's good news, is that the electronic health information as of October 6th, most of you have experience. Like I said, the designated record set is defined under HIPAA because nearly all actors that are involved in this are HIPAA compliant. Okay, the designated record set is it's a keystone that's shared between information blocking regulators and the HIPAA privacy rule. Remember what I said before, it's just HIPAA through a different lens. Odds are pretty good if the electronic health information you're using is covered by HIPAA, you're going to be okay, at least for the most part, under information blocking, okay? It's just what you do with the information that's a little different. The same electronic protected health information that an individual has a right to access under HIPAA is the same information that you cannot block, okay? Or you will not be likely to block, because remember, that was part of the statute. So that, I hope that puts a lot of minds at ease, because you're from HIPAA is something you're familiar with. It's a comfort zone for many of you. So that really takes care of a lot of the mechanisms that we're talking about. Okay. Ideas for compliance. What could be potentially helpful in terms of your ideas for compliance? Potentially checklists, sample policies, developing workflows, ensuring clear issue ownership within the organization. Who owns which compliance steps? Potential organizational issues. Does the left hand know what the right hand is doing? Roles of different actors within the within the company, within the structure, and responding to complaints. I don't know, simple customer service, I guess. Responding to complaints of information blocking. It probably is beneficial down the road because, like I said, in terms of adjudication, this is not going to a court. It's probably going to be heard, if you end up in this situation, odds are good it's going to be before an administrative law judge or something to that effect. And when something is as complex as this, agencies have what's called administrative law judges because they're considered the experts in very specific areas of law. So, for example, labor law, you have the National Labor Relations Board. They have their own administrative law judges. And if you have a dispute over a statute, they're the ones who hear it. Transportation, if you have a dispute over something that is handled by the Surface Transportation Board, an administrative law judge will hear it. that's probably where information blocking cases will end up. And if you are responsive to complaints, that will probably go a long way before the administrative law judge. Again, though, in the last 5 years, we've seen 500 complaints. That's 100 a year. That's what, 2 a week? For a society as litigious as ours, not a lot, you know? So it's a, it's not something that that is currently on a lot of people's radars in terms of their in terms of knowing in terms of the path they take for the grievance that they have, and probably because a lot of people aren't aware of it. It's like I said, it's fairly obscure for most people. Most people are going to complain to their doctor. It's only after a long time they're going to figure out something's wrong with their records. So that's kind of it. I've taken about 40 minutes, which is about what I wanted to. I will try to answer questions if I can, if there are any. I want to give you my contact information because you may think of something, someone may watch a recording of this, have additional questions. Like I said, my specialty is in behavioral health. And behavioral health legislation and policy. That's my expertise. And when I was approached for this webinar, this is why I was approached. I was found through my membership in the Behavioral Health Association of Providers, BHAP, which is an organization that represents behavioral health associations. So feel free to follow me on Twitter. Be warned, if you follow me on Twitter, it's kind of a weird hybrid between my professional life and my personal life. So there may be a few tweets on there about the New York Giants, or, maybe a picture of my 6-year-old beagle. But once you get through those, you get to the behavioral health, and you can probably learn a lot about behavioral health developments through that. So with that, I want to thank you for your time and attention. I want to thank our hosts. And I'll see if there's any questions I can answer. How does this apply to therapy notes is the first question. It does not. Psychotherapy notes are not in the protected sphere. You will never get dinged for data blocking for not disclosing psychotherapy notes. They do not apply. The legislation does not apply to psychotherapy notes. Another question: are policy limits patient? I'm just reading them out loud because I don't know if everybody can see them or not. Our policy limits patient access to progress notes and needs director approval with the goal of protecting patients and undue harm. Is this acceptable under the exception? It would seem to me, on a very basic reading, and again disclosing I'm not an expert in the law, I'm an expert in the policy, but in reading the policy, it would seem the exception does apply. There is a harm exception. So the goal of protecting patients and undue harm is pretty clear in the exceptions. It's listed pretty plainly. So you don't need to work yourself into any kind of mental gymnastics to be concerned about that. Be prepared, of course, to illustrate, if this comes up, what that harm would be. It's not what we call in law an absolute defense. What is an absolute defense? It means if I state it and it meets the criteria, boom, I'm done. Truth is an absolute defense to defamation. If I say you like to run down the street at midnight in your boxers, and you sue me for defamation, and I produce a picture of you running down the street at midnight, boom, it's truth. It's an affirmative defense. Question's over. These are not affirmative defenses. You can't just say, well, I thought I wanted to prevent harm, so I'm done. Be prepared to explain in greater depth why you thought you were preventing harm. I'm not sure what the standard is there, but just be aware that you may have a little more explaining to do. But that as a policy, as a standard of your practice, perfectly acceptable. Does this mean that patients should be able to access all chart information through a portal process or other means? That is tough. Now we're getting into very specific areas of information. I don't know if it's something you need to disclose off the bat, in terms of, hey, when I get my, if I go to my electronic health records and I have had blood work, I can see my blood work. Here's your A1C, here's your liver enzymes, here's your, bilirubins, whatever. I can see all that. But there are other charts that are different and more complex. I am not sure if you have to disclose them off the bat. I would think no. The question is if you have to disclose them if they're requested. That is really the question. And unfortunately, that's a little too detailed, because like I said, I don't practice in this area of law per se. I just know what's written and what the rulemaking is. So as far as I could go, what I would look into if I were you, if you asked that, is the difference between having to disclose off the bat and having to disclose if it is requested by a patient. Go ahead.
We've, from an EHR perspective, we've seen a few different interpretations of this. We've seen hospital systems make all historical patient information and information as it happens immediately available through the patient portal. Because there seems to be a little bit of a gray area, we are going to provide, from a Best Notes perspective, we're going to provide you a button which will allow you to portalize all documents, as well as giving you the ability to make an exception for documents you don't want to be made available in the portal. So those are some new tools coming down the pipe. I bet you'll see those next week. But as we learn more about the interpretation of, does this immediately need to be available, or can I still have control over when I make something available beyond a patient's request? We'll see how that plays out.
And the last question I see is, can you please clarify for the group, my understanding psychotherapy notes are handwritten notes, not part of the medical record, like session notes. That's really interesting, because that comes up a lot in substance use disorders, which is my specialty. And there's even questions. I've even gotten questions on electronic health records of, well, if I enter them in a computer, does that make them electronic health? The key is whether they are incorporated into the larger record, I believe. So handwritten notes are indeed not part of the medical record. That is correct. And again, the exception is pretty clear on psychotherapy notes. What you just need to be cautious of is if you use any part of those notes in another part of your record. So like, let's say you're compiling a referral, or I'm not a practitioner, but let's say something from those notes makes its way into another part of the record, then you're in a different territory, and then they may have to be, and then those aspects may have to be disclosed, but the notes themselves do not have to be. Does the Cures Act state that the EHI needs to be available in the patient's primary language? Oh, that's interesting. I don't believe that is specified. And if it is, I missed it. I rarely, let me say this, I've been working in legislation for over 20 years. I can't think of a single piece of legislation that has ever said, blah, blah, blah must be produced in multiple languages. So the legislation doesn't state it. However, there's that word again, ethics. If you're not providing a record for the patient that is accessible to them, you've got some ethical questions. So that's a really interesting question. The answer, my favorite TV show of all time, The Simpsons, Reverend Lovejoy has a saying, the short answer is yes with an if, the long answer is no with a but. So, it's to answer your question, no, the Cures Act does not state anything about primary language. However, as someone, who has a duty to provide information that is accessible to a patient, if it's not in their primary language, I don't necessarily consider that accessible. So if I were the attorney of the patient, that's the argument I would use. And if I were your attorney, I'd say, well, it doesn't say it has to be in English. So again, there's that argument both sides. But I would err on the side of caution on that one. But no, the statute does not claim any such requirement. So that seems to be it for the question. So I'm happy to wrap up, and I'm happy to turn it back to our host to take us out. And if the occasion arises for any of you to contact me with any questions or inquiries, please feel free. If not, I want you to all enjoy the rest of your day. Enjoy your Thanksgiving, and maybe I will cross paths with you again sometime soon. So everyone take care.
Great. Thank you so much, Andrew. I've noted this before, but we will be following up via email for all the participants in this webinar with more information about how you can use Best Notes to comply with the information blocking rule, as well as Andrew's contact information. Again, thanks for taking the time today. We'll see you all later.
Thank you.
Bye.